Hi, this is Jill Baxter with Born to be a Sports Agent. Today I'm going to talk about exactly what happened with Judge Wilkens yesterday. She decided not to approve the settlement. So why did this happen? It's simple. The attorneys honestly didn't listen to what she said during the hearing on April 7th. She specifically told the attorneys that she wanted roster spots grandfathered in and or gradually maybe incorporated into the settlement. They didn't do that, and that's the reason why she rejected the settlement yesterday. So what does that mean for everybody currently in the portal? If you are a player in the portal, if you're a player who's thinking about going into the portal, if you're a player who's in the portal that's about thinking about going to another school, here are your options. Number one, if you left a university because you were told that they were releasing you or encouraging you to go in the portal because of roster limits, then you may have an opportunity to go back to that other university. Number two, you may also say to yourself, I don't choose to go back, and I do want to go to another school. What does that mean? Well, that school also, what if they have players coming back and then you're coming in? Do they have enough spots on their current roster to include you and any players that might be grandfathered in? I would want to ask that question. And by the way, if you're a coach, you're signing people out of the portal, you are going to want to ask the same question also, like, would they consider going back to their other team if they knew they were grandfathered in, if the answer to their question is they were told to go in the portal because of the roster spot limits. So this next part of this podcast, I'm going to talk about the legal implications of this case and actually tell you exactly what the order says so you can follow it. And why did this legally happen? I think that's the more important question. There was a lawyer that argued during the settlement hearing on April 7th that under the federal civil procedure rules that the roster limit would be subject to appeal by the Ninth Circuit. Well, why would somebody be able to appeal a confirmed settlement? Well, because of the specific rule that this lawyer cited, the rule basically says that if you treat one class member different than another, and that class member cannot opt out of the settlement, then that would be grounds for appeal. So what is Judge Wilkens really trying to do? What she's trying to do, she wants to make sure she confirms a settlement that is going to be legally sound so that it does not get rejected by the Ninth Circuit on appeal. Her rejecting the settlement based on one reason is not an appealable event. But if she had confirmed it with the roster limits the way they are in the settlement, it would have been rejected on appeal. So she's just trying to protect everybody from the whole thing being rejected on appeal. So why didn't she just redline in the settlement, hey, put this in, just a stipulation that says any player or athlete who was cut or released or who is currently in the portal or might be going in the portal is not subject to the roster limits. They're going to be grandfathered in. Something to that effect, a stipulation like that. Well, she cannot change the settlement agreement that these particular attorneys entered into. So what did she tell them to do? She told them to go back with a mediator, and she's giving them 2 weeks to revise the settlement again. And they need to specifically revise it in regards to the roster limits. So again, where does that put people that are currently in the portal? Or, hey, I'm a coach and I'm got 10 recruits coming in tomorrow that are in the portal that I might sign. Well, I think it's a good idea to do your due diligence and ask the player, well, why did you go in the portal? Oh, if they answer, I went in the portal because I asked for, $10 million and I wasn't going to get it. Then you know that they didn't go in the portal because they were told that they were getting released, so to speak, because of the roster limits. So you got to find out, did they get released because of roster limits, or did they get released for some other reason? Maybe they left because they didn't like the coach. Maybe they left because there was a coaching change. Maybe they left because they didn't like where they were living and they wanted to be a little closer to home. Maybe they left because they didn't have their major at a certain school. Who knows why a player decides to go in the portal? Or maybe they were a backup and they think that they can be a starter in a league that isn't as competitive as the league they're in. So you just need to do some research. Why is this player in the portal? And realize in 2 weeks, this whole thing could change again because the lawyers have to go back, which they should have just listened to her in the first place. Was that they should have just changed the roster limit. She specifically told them to do it and they didn't listen. So it's just fascinating to me that um and here was the argument that the defense counsel made that represents the NCAA and all the leagues. Basically made an argument that, well, we've already been implementing this change based on the preliminary settlement. We've already been releasing people based on this roster limit, and we've been changing things. And her response was, the fact that you were irresponsible and assumed that I was just going to rubber stamp everything is kind of basically not my problem. So here we are. This last part of the podcast, I'm going to just be talking about what the order said specifically to roster spots. So if you're interested in that, that's what this next part is. It's sort of the actual words from the order that Judge Wilkens specifically noted that the affected athletes cannot opt out of the injunctive relief settlement class, calling the situation inherently unfair. The NCAA argued that revising the roster limit terms would jeopardize the months-long negotiation that produced the agreement. But Wilkens was unconvinced, saying the settlement's broader benefits do not excuse the harm to those losing roster spots. She also dismissed claims that changing the settlement at this late stage would harm NCAA member institutions that had already started implementing changes. In quote, Judge Wilkens said, any disruption that may occur is a problem of defendants and NCAA member schools' own making, Wilkens wrote. The fact that the court granted preliminary approval of the settlement agreement should not have been interpreted as an indication that it was certain that the court would grant final approval. So what does Judge Wilkens suggest that the plaintiffs and defense attorney add to the settlement agreement? Here is exactly what she said. She suggested that one course of action would be for the settlement to stipulate that no members of the injunction relief settlement class who have or had a roster spot will lose it as a result of the immediate implementation of the settlement agreement. So, what I am suggesting to anybody is, particularly the plaintiffs and defendants in this particular case, is that they should listen to what Judge Wilken said. She expressed a concern in April 7th over the roster limits and how they would impact student athletes. She did not think it was fair, but I also think that there's no legal precedent for that. And when you treat one class, part of the class, different than another, the class being the student athletes, and they don't have a way to opt out, then that also becomes unfair under the federal rules. And on appeal, this section of the settlement could be appealed, and then we're back to square one anyway. So I think she's also just sending a message to the attorneys that, hey, if you want this to stabilize college athletics, you are going to need to grandfather in, so to speak, athletes who are currently on rosters or athletes who are in the portal right now that were told to go in the portal because of roster limits could go back to their school should this be implemented in two weeks. So now the attorneys have 2 more weeks with a mediator to try to solve this issue, so there is some kind of stabilization in college athletics. However, if the attorneys can't come to some agreement on the roster limits, then these cases are just going to go to trial, and they could take, let's say 5 more years of litigation and I suppose the NCAA, if they wanted to, they could see if they could win the case. Maybe they can, maybe they can't. So that's it. That's what's going on with the House versus the NCAA case and the Hubbard case, which is also involved in this settlement. There's actually... Thanks for listening. And if you want to get a copy of my book, Born to be a Sports Agent, you can purchase it on Amazon or go to borntobeasportsagent.com. If you think you need representation or want to get on my email list, go to jillmcbridebaxter.com. I have 3 different free webinars on there for a coach, if you're an aspiring sports agent, if you're an athletic administrator, really anybody who needs representation. You can watch one of my free webinars and get on my email list. So just go to jillmcbridebaxter.com or follow me on Instagram at Agent Jill Baxter. Thanks for listening. Have a great day.